Hello, everybody, and welcome to another video with Daza Greenwood. That's me. And I'm coming to you from Oakland, California. And the reason for this kind of emergency podcast is because there's a big release coming, and I didn't want one more second to go by without talking to my friends and colleagues, Cara and Rich, who are the founders of Describe, a company that I am such a big fan of that I actually joined the advisory board. And that's partly how I've got this little sneak peek into what's about to be released. And I'm just so excited about it that I wanted to get a full walkthrough. And it seemed like the best thing to do with a walkthrough is to video it so we could share it with my broader community. And so, with that having been said, do you two want to introduce yourselves to all my friends that don't know you yet?
Sure. Hi, thanks for having us. We're so happy to see you. It's always wonderful to see you, my friend. So I am Cara Peterson. I'm the co-founder of Describe. And we realized we're actually 2 years into our journey. We launched 2 years ago, and I found Daza pretty quickly on. I think I stalked you on LinkedIn and found you there. And it's been a great experience knowing you ever since, and that we appreciate you so much. So that's me. I'm the sort of marketing and business development side of things. I'm really into AI and access to the law and AI and access to justice. And that's kind of how I come at this whole thing. And I will now hand it off to my co-founder and also husband, Mr. Richard DeBona.
Yeah, I am Richard DeBona, and I I like to say that I compose and write the songs, and Cara goes out and sings them. So occasionally I go out on the stage and talk like today and get out from behind the computer, but actually I'm still behind the computer. So I guess that's not always the case. But
Mm-mm.
yeah, I'm happy to be here. It's always great to see you, especially when we see each other a couple times a year in person.
That's right. Yeah, back in the Boston area,
Yeah.
when I was situated at MIT when we first got together, and now I've made the big move back to California. And thank goodness for Zoom, so we can stay in contact, not just in person. And also, it's a really good medium to do screen sharing, which I think is what we should get to next, because I am just bubbling over here with with anticipation to check out this cool new feature that you have. And I know it's something that we've been talking about on the advisory board and that you've been bubbling up for quite a while. So it's um it's a big day. Is it true that we can now do have a citator in Describe?
Yeah, but a citator with a Y, just like describe with a Y. So yeah, I could show
That's
you that in a
that's
sec.
my fault. That's my fault.
What the Y?
The marketing. Yeah.
I actually like it.
Thank
But
you.
yeah, so we've been offering this free natural language search for a couple of years now as an access to justice, and it's been going really well. We get sometimes as many as a couple thousand searches a day on our site. It's very, very busy. Um, and everybody said, you guys are crazy for giving everything away for free. And we said, but we want to help people. And then people, even I think you may have said, eventually you're going to have to start charging people for something because otherwise you won't be there too long. So we decided to see what we could do with all this data that we created. And one of the things that was needed was people said, when I search for things, I need to know whether these cases are good law or bad law. So we attacked that. We were on this consortium with Court Listener and kind of jump started things there, and then kind of branched and accelerated our own path. And now here we are. So
And could I give
yeah,
a
go
shout
ahead,
out to
Cara.
Cart Listener because they're the best and are
They're
still
right near
working.
you, I think.
Yeah,
That's
they're up
right.
in Oakland and
Oakland,
they're working
California.
Oakland,
Uh,
like Oakland proud, right?
yeah.
Yeah. So
There is a
so
there there.
there is a there there. So they are still working on their citator, and that's going to be awesome because that will be something that they make available to people who are also building in this space. So love to them because they are powering a lot of innovation.
Yeah.
Yeah, and that's one of the great things about your interest in access to justice and your collaborative, very open and transparent way that you've been innovating. So while it is a company and there's going to be a paid service, fundamentally it's free. And not only is it free and open to all in terms of just access to law, which provides access to justice, I think, or it's part of it,
Mm.
but also your open collaborative spirit. So, the way that you've kind of worked with innovators and other other people that are developing solutions like Court Listener, but that's just the tip of the iceberg. I think is partly what distinguishes you from some other companies and other ways to do a startup, and it's just entirely agreeable. And I think finally we're starting to enjoy some of the fruits of this approach with the innovation that you're dropping today. Actually, it's more than one innovation, so we should also get to issues. But first things first, let's check out this Cytator.
Yeah, yeah. So we have this, we have a search right on the homepage that anybody can use, and this is a free search. And so you could type in any type of case facts like my neighbor's dog bit my daughter, or somebody coerced my mother to change her will, or if you know legal terms, you could type in like spoliation of evidence, or some even super complex terms that lawyers have that I don't have on the top of my head, but it'll search for anything and it finds everything instantly. Um, and I'll do that in a sec, but I wanted to show you the overview of some of these tools we have
Yeah.
in what we're calling this legal research toolkit, which, because we don't take any funding or anything, we could offer this super powerful stuff for only $10 a month for non-commercial use, or $20 a month for commercial use, like if you're using it in your job. Um, but it includes all of these tools.
That's great.
So
And if I
go
could
ahead.
just to be
Yeah.
clear, the first thing you showed, which is natural language search, is outside the paywall. It's free and open to everybody, right?
That's right. And I'll show you, I'll click it now. There's an actual search page, and I'll show you as we get into things that aren't in the free tier. But generally what you could do in the free tier, or this is the paid one, is um, search for things like if I search for like, I don't know, defendant, uh, deleted important evidence. How's
Employment
that?
records or something. There you
Yeah. So in the free one, you could search by jurisdiction. So you could put in, every state, federal appellate, federal supreme. We also have bankruptcy because a customer asked for that. In the state level, we have all state appellate and state supreme. We don't have trial courts because a lot of them don't write precedential opinions, but maybe eventually. And then you could also, I'll show you this, view in English, view in Spanish, simplified English, or simplified Spanish, which is super cool. I'll show you that in a sec. But I'll just type this in and hit search. And everything we're about to see is real time. Like our stuff is super fast. So one paid thing here is as I go through, you'll start seeing this history build up. So as we go down rabbit holes, you'll be able to see where you were and then go back to it instantly.
Yep.
But
And I
next,
can see already here under the main legal theme, we have the kind of official legal jargon of spoliation.
yeah,
Good
But you
job.
didn't, and very, very really critically, you didn't have to know that term to get this, which is the whole brilliance of what you're providing here, which is its natural language, sort of
Mhm.
and because of the way these kind of high dimensional vector representations of language work, and in this case, legal domain language, it's the idea, it's the concept the pattern of the concept that's picked up. So finally, everybody can play, and not like you're unleashing the meaning and the value and the usability of the law for everybody who's able to speak words and understand words and type words.
I'm glad you pointed that out because I may have forgotten to. But yeah, if you're a lawyer using this, you could type in spoliation of evidence and see things. If you're just someone who wants to know about the law or you forget the term, oh, I know that term somewhere, but oh yeah, now it's spoliation. So you could type it in however you want and get to the same results. And as we go through, maybe I'll use this word to key off of now that we know our legal term. But what we get here is next to each case, you get a little treatment indicator. So this is all instant. Let me see if I can find one. A lot of cases are not treated. This one looks like this was treated, it was followed by a non-binding court. So it knows if the places that followed it are, this maybe wasn't a great case to find overruled things, but we'll get into that in a second. But if I click a case here, then we could see details about it. So in this case, we see an overview, we see the citations for it, we see an analysis of the whole case. Um, so this was a trial court level. I guess what I could do is search for this, but maybe I'll narrow it to Supreme Court and see if they ever decided anything about um, deleted evidence.
They must have, you know.
And now it's going by that. The search could sometimes be the slowest thing. Yeah, so here's one, Clifton versus United States. So in the search results, it shows you the treatment instantly. You don't have to go and click like find the treatment or the trademark word by that exists out there for like Shepherd Eyes or anything. You just get the treatment. So if I just click one of these, I get the um, case details. It shows the citation. Here's like the federal reporters. It shows the electronic citation some of them have. Like this is the actual Lexis citation. Oh wow, it's really old, 1846. And then it gives you an overview of what the case was about. And then down below, there's some details about the case. This actually knows that this is the court of last resort. So once you get to this, that's it. Published presidential. It tells you if it's on bank, which means if all the judges listen to it. I guess that doesn't apply to Supreme because I think they all listen to everything. Um, and then it gives you a fact summary, disposition, etc., and what kind of authorities it used. But then there's this, there's this, actually, let me go here and then we'll get back into the issues in a sec, because
Okay.
this links into something else.
Yep.
Um, Down below here, now I click summary, and this is what, if you have the free version, this is what you'll see. And this is kind of like, if you remember Cliff Notes of books, this is kind of like Cliff Notes of the original opinion. So it tells you what this case was about in a summarized way. And I could instantly translate it to Spanish or simplified English. So this is at a fifth grade level. The court talked about whether there was enough reason for the United States to go ahead with the case. They agreed that there was. So it's nice and simple. And then there's simplified Spanish also. So that's in here. And then over to here, again, this is in the free version. You see the original opinion. So if you want to read the original, this is, what lawyers have had to use up till, AI came around.
Yep, which is
And
great. When I think about the way I would, for free on a browser, find cases, like after I was out of law school and not working as a lawyer in an organization that had high price subscriptions to say Westlaw or Lexis, for example, I would end up going once they finally put it online to like the Legal Information Institute or something like that, where they have the cases available, or they have statutes and regs, and then basically all I get is the original. So like I'll do a word search, and then hopefully it'll pull. I'll find like the statute, the reg, or the case. Um, and that's the last thing that you're clicking on. So like we definitely need that. That's the authoritative, statement. But it's all these other buttons and even the nature of finding and accessing and relating things based on the meaning and the concepts of the language is like mostly what you're providing here, but it doesn't stop there. You actually provide the cases, which I know took a ton of time to go and like and to collect those and to extract, transform, and load them in a way where they'd be immediately accessible and linked to all the other analysis. But I just wanted to highlight that last little button that almost as a afterthought you clicked on,
Yeah.
the only thing we had access to, and we used to think that was good. Like I
Mhm.
remember when we first finally got cases and statutes and regs online. I thought it was a triumph. Obviously, we weren't done yet because they weren't fully usable, and we didn't have all the bells and whistles of the high-priced, legal, research providers. And now with AI and with entrepreneurs and innovators like yourself, we can maybe finally fill that gap. So I just wanted to highlight that aspect of this kind of like toolbar and menu that you're highlighting now.
Oh yeah, that's great. And that reminds me, like if there were other opinions, like a dissenting opinion or a concurrence opinion, they would show up here too. So you'd see all the different opinions because a lot of Supreme Court ones have dissents, obviously. Um, but here's some of the cool stuff that is brand new and we think is pretty cool. If I click this citator, you could see in here already it shows the treatment of the case overall. Um, you could see these are all the cases that have cited
Hmm.
Clifton versus United States. Okay. And it shows how they treated that case as when they discussed it. So a lot of these they followed binding means that in this case, like it was also the Supreme Court. Um, non-binding means that it's other courts. Obviously, any court other than the Supreme Court would be non-binding. So that's why down here you see, um, this non-binding one from the district court in Eastern District of Virginia. But what's cool about this, besides the treatments, is we see the issue that they actually talked about or distinguished. In this particular case, the court limits Clifton to its facts, knowing it did not address whether a jury may hear inadmissible hearsay or probable cause, and declines to apply it to the present procedural question. So here we could click this info and it gives you a little explainer like this is distinguished by a non-binding court. It found the cited case inapplicable or unhelpful, and it gives an example. And it's not useful for this issue, but not criticized overall. So
Perfect. And that's the essence of what we mean when we say citator, right? It's like where else cited to it, but it's not just a citation. It's what is the meaning of the citation in the context of the later case or the related case, and was it overturned? Was it
yes,
affirmed? But then there's all these other gradations that you're getting into now. Is like distinguished. It was like partly applied, and you've made that so easy here with the colors and with a click, a mouse over.
yeah,
So you can immediately see it and then click down to those cases. And not to mention, you've also then extracted and provided a simple overview right here, like Clifton is listed among cases recognized, blah blah blah. So it's just you've just taken all of the hard research work and encapsulated it into a simple at a glance UI. That's pretty cool.
yeah. I've been looking at cases obviously during all the testing that we've been doing and everything. And this particular case doesn't have it. But one cool thing about this issue level is it is completely possible to have multiple issues that another case like Griffin versus United States could have just as easily discussed three different issues from this case, followed two of them, and overruled the other. So case level treatments, which you get currently from other tools, would have just showed that case as being overruled, but in reality, it was actually followed on two issues. So maybe those issues are the ones that are applicable to you. So you might be able to still see if they're usable. So that's like a partial overruled or whatever. But now you get it down to the issue level, if that makes
And we
sense.
and
Go
we
ahead,
can't
Cara.
thanks. And we can't say for certain because and never really should, but this feels a little bit new out in the market, right? This level of issue level citation, right, Rich? That's kind of your impression from what you've seen.
Yeah, I think it's been hard to do up till now with um because um citators have relied on thousands of human editors, which is great. It's super expensive, but to ask those human editors to not only say whether the case was overruled, but now go and find all these issues and whether those are overruled or followed too is a little bit too much of an ask, I think, with
Mm.
how dense some of these opinions are. And it happens to be like we use the most advanced model for this. And and I don't even think the models from 6 months ago could have done this. I think this had to be a model that understands a lot of nuance in language to be able to do this issue level. So
Mhm.
this is pretty new, I would say. Um, and so in addition to the citator, so you could see this for any case if it exists. Some cases never get cited because they're new and they haven't been cited yet, or just maybe they're just are a basic paragraph that say they were affirmed or remanded or whatever. And so there was nothing that anybody would need to use that case for. We also have this thing called a backward citator, and I don't know what it's going to be for this case, so let's hope it's good. Okay, so the deal here is when cases were written at the time the judges wrote them, they also cite other cases. And so what this does is it goes through the opinion and sees how the case when it was written cited other cases. So in this case, Clifton versus United States cited Locke versus United States. You could see this one's even older, 1813. And the court relies on Locke United States as an authority that general verdict is valid if supported by at least one good count, applying its rule to the present case. So if we were to go into the original, and if we were to go into the original, um, we would see like Locke versus United States was cited here. In some of the cases, maybe we'll see one as we're going further in the demo, we'll have like, 30, 40, 50 of these. Some of the citator cases like Miranda or there's Erie is there's some of these big cases that have been cited over and over, Brown versus Board of Education. They have thousands of these things. And so this, we show I think we stopped showing them at 2000, but we limit the non-binding ones. So we show all the binding ones all the time. But some of these things just have been cited so many times that it's crazy. At first, Miranda actually blew out my system, and so I had to come up with a workaround because it's been cited over 10,000 times. But
Incredible.
yeah. So
And then yet again, just
oh
FYI,
yeah.
when you click on the citator, and I just wanted to, oh, can you go
Yeah,
back to
sure.
the citator? So in addition to the color coding and followed and so forth, if you will now want to take a look as, like when I used to practice law, I would always, for the cases I was going to mention, then click on what you have here, the button full case, and then just be
Yes.
like, let me just take a look at that. And not often, every so often there was something in there was like, I don't want to stir this can of worms. I can talk about something else because I
Mm.
don't want the other side to look at this, or there's stuff in there I don't really like, or maybe I didn't totally agree, even sometimes, rarely, but sometimes I didn't agree with how it was mentioned. I didn't think it stood for that necessarily. Um,
Yeah.
but the other thing is sometimes there's a little treasure trove. I start reading and I'm like, oh my God, it's got all this other good stuff that sort of relates in different ways.
Yeah.
Like they
Right.
mentioned one thing that, but as you said, humans are, even when you can hire an army of law librarians and taxonomers, we have limited throughput, and limited attention. So at some point we have to make a judgment call and
Mhm.
prioritize what we're saying something, when we're going through and we're kind of like doing our annotations. But when you actually read the cases, they're much richer than that, and and,
Yeah.
and the lawyer can make a lot of combinations. And so the two interesting things about that in the context of what you're showing now are number one, you've unleashed some of what is the potential of the new most capable large language models to surface all of that and then programmatically make the connections and cross connections to a given case, which is really exceeds the buffer of most of humans, I believe. I don't think that's a controversial statement at this point for anyone that's used this technology. And then number two, it's at a click. So like I just do a click and I'm right there at the case, and now I can see all of its inward and outbound citations as well. So it's just really interesting. I have to say, just seeing this part of the demo almost makes me feel like practicing law again, even though it's been many years. But it was like this easy to just do the part that I want to do, which is the high bandwidth kind of judgment part. That would
Yeah.
And
it's very, it
that's the
used to be
point.
so tedious doing
Yeah.
this stuff. And like,
Right.
it actually looks fun. Like it's fun to click around in your system.
I'm so happy to hear
That's
you
awesome.
say that because, and I won't go on my soapbox, I promise, for more than a second, but like one of the things that we like to talk about of why AI in legal is so important is actually the improvement that it can make in the the practice of law in people's lives who are actually in, attorneys, or they're doing this legal research. It's a high burnout, high stress profession. And we think maybe that's a part of AI in legal tech that could get a little more attention, is if it can make the job better and less tedious and horrible, isn't that great? Because then more people can be happy lawyers and help more people. So
Yeah.
Amen.
Yeah.
And
That,
of
yeah.
course, you don't have to be a lawyer to use this system either.
No,
no.
no.
People aren't
I mean,
lawyers,
Mm-mm.
we
but
have, we have,
everybody's subject to the law. Ignorance of the law
Yeah,
is no excuse.
I
Access
like,
to the
yeah.
law is fundamental for access to justice and the kind of
exactly.
free, open society that we cherish. And so just good for
Yep.
you for making this available. Okay, now I'll get off I guess I joined you on your soapbox for a
Yeah.
minute.
Come
Uh,
up on the
No,
soapbox.
that,
but
and
okay,
this is a good example. This actually has,
He's literally
this,
rubbing his hands. Did you see that?
who was me?
me,
Daza, though, he's so
I would be
I
excited.
like,
He's
would too
literally,
if I
"Arr."
wasn't on my keyboard and mouse, I would be too. But this actually has multiple opinions. So um you could you could see all these opinions if you wanted to, like, and read them all and see summaries of all of them and all that. But let me just go back to this. If you notice, I don't know if anybody noticed, but you could rewind and see when we clicked this other full case, it came up in like 1 second. We're not sitting there and taking 40 seconds every time the screen draws and all that. But we'll just look at the citator on this one quick. Again, this looks like other Supreme Court cases followed this one a lot. And then what usually happens is on the non-binding, which, oh, this is a nice big one. So we won't bother going down too far. But the it, like Daza said, you could go down these rabbit holes and click on this, and maybe the backward citator will be more robust here. Yeah. So on this particular one, this is how interstate circuit versus United States, what the judges were actually citing when they wrote this case. So this is going back in time. If you think of a citator itself as what happened after a case was published. So when they wrote this case, they had no idea that how many cases would be citing it. And
Mhm.
they probably thought it was good law. In this case, it ended up happening to be good law. But when the people wrote like Plessy versus um, whatever for
first.
Yeah, Ferguson. Yeah, they did not know that it would be overruled and all that. They thought segregation was going to be the way forever. So, but the backward citator shows you what the judges cited when they were writing it. So in this United States versus General Electric, oh, and here's a oh, I thought I saw one with multiple issues. I get excited too. But you could see again, this is how they treated it. So it gives you another I this is another feature I don't think exists in seeing, well, maybe it does. I shouldn't say that. I don't know if it exists at this price point to be able to
There you go.
see how a case cited other cases and see the treatments of those.
Yeah.
In a lot of cases, you're going to see a mandatory type thing because it's another Supreme Court case here. But obviously they're going to follow a lot of things when they're writing the case. But anyway, we can move on. Um, Let me show you the analysis here. And this is something you mentioned earlier is these issues. So in addition to case details, where it shows what the authorities were and everything else, we pulled out all of the issues and how they were addressed from all of the opinions. And then we show them here. And we show what kind of outcome they had, procedural postures, is it a holding? Sometimes it's a partial holding. Sometimes some issues have all these things, some issues don't. But you could go down and see interesting things about this. But then you could go and click see similar, and it'll bring you into our one of our other tools, which is called our Legal Issue Explorer. So if I
Yeah.
click that, it
This
takes,
is so important. So now we're no longer in the Cytator, which is big news, and congratulations on that launch. And we're in the now tightly related kind of release feature space of issues, which I think I was telling you before this video that this is partly because I don't cite cases anymore, but I definitely deal with legal issues. This to me was sort of like the most thrilling part of your release, as I've been clicking around like since yesterday on the issues. And so I hope we do take a moment here to sort of like to dive in a little bit deeper about what they are, and maybe we can take a moment to understand how this is different from the citator and how it's different from your natural language search, and think ways people can use it, and how the issues are related. I think that would be a good start, and then I may have one or two little insights to add when you're done.
yeah, sure. So here are cases that, so what happens in the Legal Issue Explorer? Um, I'll go
Maybe
back.
try, I was
Yeah, I'll
gonna say, yeah,
start
do
from
a
here.
different example. Yeah, I think
So
that'd be
I'll
good.
sit. So we learned that term. Well, probably most people already knew it, but spoliation. So you could see as I type here, I'll do a little slower. SPO, and you could see spouse. Then I type in more letters, and we're in spoliation. So I can move, I could type in things and it's autocomplete and it fills in this bottom part with all the legal issues from all the cases.
Can we do culpability and spoliation and negligence standards? It's the right column halfway through.
This one?
Yeah, because that one's going to be rich vein. I can tell.
So,
Anytime you have like tort involved in any way, it ends up being
yeah,
a
sure.
whole like, like I don't know what, like a beehive of rabbit holes, like like the way, like a honeycomb of rabbit holes.
Yeah. So this is all the different issues, and you can narrow by jurisdiction again, but I'll just go ahead and click this. And now what we're going to see, and you could see how fast that is.
Yeah.
We're going to see all of the cases that dealt with culpability and spoliation and negligence standards. So there, there's not many that dealt with that exact thing, but there are some that dealt with something similar, negligent spoliation of evidence. And then we see treatments next to the ones that have treatments. So here's one. um, and what happens here is it shows the treatment, but it also shows what the main legal theme was, so you could see what the case was about. But it also shows how the judge applied um, this. We were talking about, what did we talk about? Negligence, spoliation of evidence. So you see how the judge applied it and addressed that. I should say addressed, not applied. How the judges or judge addressed this issue within this case.
Yep.
And then again, you could click here and it'll tell you this positive binding same court later decisions rely on this and follow this case. And you could go into the citator, or you could go into the case as a whole. Here's some yellow ones, which mean that they might, this one is, it's cautionary. So later decisions distinguish or decline to follow this case. And you could go and look in them just like we saw, and click around some more and
And
see.
if there had been a red, that would have been like red alert. It's been overturned, or at least partly overturned, right?
Yeah, when we go to case name search, why don't we go to one that I know was overturned, and it's pretty rich source. It's even more of a beehive than what we just looked at.
Which is
Um,
so interesting, by the way. So I know we're talking about issues, but it's just such a lesson in how all this is interrelated. So issues
yeah,
matter, but it also matters like, is it good law? And what is an issue? An issue arguably is the like result or like the dot product of statutes, regulations, and case law in like, like infinite, directions of facets on it. So it's like the law is a rather complex, multifaceted thing. And this is one way to start to be able to get a handle on it and to see that a snapshot of the dynamics of what the law is at any given moment and how it relates.
Mhm.
love that. Yeah, and it's mind blowing. I mean, my brain is so fried to even think about what you just said is like mind blowing. But it is fun. It's super fun to think about this stuff and to click around and learn and just use this even if you're not researching anything in particular.
Just by
So
the way, just FYI, we all drive around differently, but what I would have done and what I'm going to do when after I'm done
yeah,
working today, when I go back and play with this more, is I'll probably find this issue again, and then I'm going to go all the way down and be like, okay, I just want to start figuring out all the people that like allegedly accidentally deleted all the email. So like negligence, but the email like argue might have been, evidence in something they were involved in. And but was
Yeah.
there an order or not? And blah, blah, blah. And like what were the good excuses? What were the bad excuses? And
Oh,
start to
yeah.
derive from that a
yeah,
little bit better hygiene in terms of, like my own advising for like data governance and
Mm.
stuff like that. Because it's just a fascinating way to get into the nature and the application of the law. You can do it through the lens of issues.
yeah, yeah.
Mhm.
And then you get into other issues like this particular case. Now we're into this one, not only talked about spoliation, but public policy and duty to preserve evidence. And you could see that it used the three-part duty test to um, address this issue, and some of these Indiana Code sections 35. So you could kind of see where to drill down on further research. And then you could click see similar and keep going down the way we did.
Yeah.
Um, in the So that was Legal Issue Explorer. The keyword search is fun because this is where,
Explain why you built this.
yeah, so sometimes people want to search for specific citations or party names or statute numbers or just specific words that may not be natural language. And as you know, like numbers and things, like natural language doesn't do as well if you try to just say, here's a citation number, because it doesn't have a context in the real world of what that is. In a lot of cases, it'll still work. But what we did was build a similar, it's kind of like a Boolean type search that people might be used to in other tools. So if I
Mhm.
just I'll type in our example here, um, spoliation, and then I'll just type in damages just to narrow it down. And we could see as we're typing again, we get, um, this is from the original case, the original opinion and where these words occur. And then we have our described summary of the part of the case where this was, so you could see what they're talking about in here. And of course, you could go to the original case again, see the treatment from it. Um, the keyword search is the best way to think about it. The best way I think about it is we built this massive index of every single word in every single judicial opinion, and then put like an instant search on it. So kind of like a, actually I shouldn't say that because I have no idea what Google does behind the scenes, but I know that we made it so that you could search by keyword against this massive index. And there's a couple different search modes. So you could search sequential, the words have to appear in order, proximity, they have to be near each other, and you can narrow down by jurisdiction again. And then we have this nice little quick search guide so you could see how to search for things. Like if you put quotes around, it'll be exact, etc.
Dynamite. Wait, how did you click? Where did that?
Just
Oh,
search guide
search
here.
guide. Okay, it's in red, and it's weirdly I didn't even notice that
Yeah.
before I clicked it. This would be like when I was in law school, where I'd just be like, I have no idea what I'm doing. Now is when I talk to the research law librarian.
Yeah.
What exactly were like the regex bizarre symbols on Westlaw versus Lexis to say like this word within seven of that word, but not
Yeah.
the other word?
Yeah.
And you just click it right there, and it's, oh man, I cannot wait to play with this toy now too.
Yeah, this is a fun toy. And this is where you could type for people's names. Like if you typed in Lakewood or Unigard or anything, you would get these types of things. But if I typed in Lakewood or Unigard in the natural language, I may not get the same results because it may not know that what Unigard is. I mean, it may, but it's not as accurate as
Yeah.
this. So this just serves a different purpose. And then here, case name, we also gave a way to search case names. So this is by jurisdiction, and I'll bring up a case that I did a lot of um, testing with for the citator. I'll just type in Plessy here, and you could see that was quite instant.
Yep.
And oh, what happened?
And we've got the I
Oh,
think,
it auto completed to Posey. Stop auto
and
completing
it's
Mac.
very appropriately got the red because it
Yeah,
has
so
in
it's got the
fact been
red right
overturned,
next to
thank
it.
goodness.
So we'll click it, and then we see the analysis, um, and we could see what this was about, Homer Plessy, and the disposition, remanded issues, etc.
I love that.
Involved
Key authorities, the 13th Amendment, because like
14th Amendment,
we
15th
have a
Amendment.
result
Yeah.
from the Civil War, and it clearly requires the overturning of this case.
Yeah.
Yeah.
And then so now if we click the citator, we see that things just overruled it over and over and over, including Brown versus Board of Education, which is the most famous one. And this is where it overruled it not just on one issue, but on two issues: application of separate but equal, and then
Mhm.
constitutionality of separate but equal under the 14th Amendment. So it pulls out all these
Ooh,
issues.
wait, hey, what's this one? Missouri. Who's following it, and on what
This is what
aspect?
year was this? 1938. So they must, this is like, oh yeah, we're fine with yeah, the court adopts and it applies Plessy versus Ferguson as binding precedent to uphold the validity of state laws requiring separate but equal accommodation. So back in uh, 1914, they
1914.
were perfectly fine with the separate but
So
equal.
if we click on that case, then we should start seeing some red in the
So I would assume
some.
what happened here is people just stopped using this case
Oh,
after
right, of
Plessy came out.
course. That's right.
So so they followed it, and then Plessy came out and people are like, okay, this case is
Could we
obviously
go down to the issues in McCabe here? I've
yeah,
never heard
sure.
of McCabe before. I guess it's like not it's a rather obscure case apparently. But if we go down to the issues that say segregation is cool, is that the first one?
Oh yeah,
Separate but
separate.
equal. Yeah. So now if we click on one of the things that, although this case wasn't cited, if we do it by issue, which is partly why I'm so bullish on these
Do
issues,
you want me to click
in,
this?
I think let's try it. And if it doesn't
Okay.
go well, I promise to edit a second thing.
No, you know,
I think this is going to go well.
it'll
I
go
really do.
well.
So that we should start seeing the shape of the law here, which where we know it took an acute angle and went a different way at a
Mm,
certain point. That should be obvious here, I would think.
Yeah, so here's some ones that a lot of distinguished,
Yep.
and then we oh, here's one that started to overrule it in
1940.
1946. Yeah, we do not have the ability to sort by treatment right now.
Yeah, that would be so that's something to think about for later because I know it's
Our
obviously in
first feature
here.
request from the new
Yeah,
tool.
I have a feature
yeah,
request. Two
Yeah,
things
good.
actually. Sort by that way, but also sort or filter by no sort, I guess, by time. To go
Yeah,
like most current to least current would
oh
be
yeah, yeah, yeah.
double.
We have that for the natural language, but to do by this
that would be
would be
good.
kind of cool. Yeah.
Yeah, I mean, so it's there, which is the main thing. So if you scroll and you want to note the end of it, you can know everything.
Yeah, and here's some
Um,
old ones that followed it again.
Yep. So you got to look
Mm,
Um,
at the date, which is also such a lesson when you're looking at the, you've exposed the law. And one of the things that you have to know now, and you can give people more crutches or whatever, like more supports later as you bring more features in to sort, filter, and search. But everyone has to know the law is a dynamic river. And so you have to know what snapshot in time are you looking at.
yeah,
To be able to roll that, like point on the timeline forward and backwards, know what the law was at that point or what
mhm.
what a precedent or a statute or reg or whatever meant in a given point in time, and then that's just terribly important, and you have all that information here.
yeah,
Um,
yeah, yeah,
yeah,
yeah. And so I clicked through, and this is another one where you could see what cases overruled this, what cases distinguished, some of the issues that they use this one distinguished on two different issues. And this sorts by treatment on the citator. So the most important, like the negative ones, then the cautionary, then the positive, and then the ones that just mention are down the bottom because actually there's ones that just cite it without even talking about it. I don't know if that's here, but yeah, I'm scrolling kind of fast, but
yeah. I remember you posted
again,
we were building
you
this
could
out
just
on LinkedIn, how like there's like an endless variety of weird tangential mentions of other cases that you then need to figure out
yeah,
how to characterize. And I guess
Yeah.
you've
and
probably drunk as much out of that fountain as any other person on earth at this point.
oh God. And then this backward citator is actually kind of cool for this case because you could see on Lane versus Wilson, they talked about it when they were writing Colgrove and judicial power to remedy voting rights violations. They distinguished from that, but they followed it on this, on a slightly different issue.
Yeah,
And they
got
seem to do that on different issues for a lot of these. So you this issue level citating both forward and backward is actually pretty cool. And the nuance I think will be good for researchers and fun to research.
Mhm.
Oh yeah, and practitioners too. So like
Yeah,
what
and
what I think you're
practitioners.
showing me, if I was going back to have to argue with people about the law, um, which again I'm starting to warm up to that idea. I would this to me it's sort of like I feel like I'm going to Blick or like one of those like awesome stationery stores and getting 10,000 different colored pens that I can now get onto my canvas and paint whatever picture I want, with
Yeah.
all these gradations. Like, oh, I want to start like pulling on this thread that I can distinguish this set of issues that all together, when you put them together, obviously inexorably means my client wins.
Yeah,
You can
yeah.
love how like how
Oh
they
yeah,
break
that's yeah,
down.
yeah,
And
Yeah.
it's a prism of issues,
Mhm.
that becomes a lens of what the law is, and so what's our vantage point, and kind of like what amount of focus on what types of things do we want to do. Finally, we've got some tools to do that in a very cool way that I can't wait to see how people start applying this in their practice.
Yeah, and that's a good point. And I notice I did not have to click Lane Wilson and say fine treatment, Guile versus Harris, fine treatment, Great Lakes, fine treatment. Like I don't have to go through each one and have the AI try to find all the cases that it's cited and treat it and do it in a one-off way. This is right there for you, right
Mhm.
instantly, which
Yep.
I think is a good differentiator for us. And then
Yep.
the last tool that I want to show you really quickly,
What's this one?
this is our citationator. And so what you could do is
That one's
analyze a
also my
brief,
fault. Anything with a Y is my fault.
except for
Okay.
the original Describe. We also own Describe.com.
Oh, that's true.
So so what I'll do on my other screen, that's why I'm looking to the side. I actually have a brief. You've read in the news about all these hallucinated cases and the lawyers getting in trouble for submitting ChatGPT briefs. I got my hands on one of them and I'll just paste it in here. What you could do is take any brief or
Go to the
document
top. Yeah. Yeah.
and this is an actual one that somebody got in trouble for. And you could do citationate. And even this is fast, you could see. And it
Ooh,
brings up
not found. Three not
there
found.
were three not found, three were ambiguous, but it also does the treatment of your citations, which is super cool. It applies our citator logic to here.
And this is new as in like literally, I think you just built this like a day ago.
Well, the treatment part, we
The
had
treatments,
the,
that's what I mean.
yeah, we added the treatments in. It took a
Yeah, the
long time, but
citationator's
we
been
launched
around for
it.
months. Yeah.
Like, yeah, we just launched a lot of this stuff.
Yeah.
So here's one that this could have been the one they got in trouble for. I don't personally know, but it's highlighted in red. And so you should take a look at it and make sure. Like maybe they got the reporter wrong or something. Here's one with the treatment. The citator treatment on that is unknown, but it identifies electronic database ones. So you could double check that that's the right thing because sometimes I don't know if you're allowed to cite. I think are you allowed to cite off Westlaw and Lexis nowadays? I think it depends, right? But
I
it
think
brings it
you
up to you.
and and then depending on what the tribunal or the like the administrative office, like they all have like their kind of standards, and they say how you are and aren't supposed. At least it used to be that way. I shouldn't even
Yeah.
talk about this. My information is fresh off the historical records of the 1990s. So who knows?
But in any
Yeah.
case, it'll identify the electronic ones for you. So you could see like, should I use this one or should I go and find a reporter that's not an electronic
Yeah.
reporter?
And
But
I
then
guess
what
the
we,
important thing
oh,
is like, so
sure.
you've got your brief, you copy and paste it in there. So let's say like you weren't trying to play gotcha with someone else's brief,
Yeah.
but you've got your brief and or your
Oh,
other.
you can play
You could play
gotcha.
You
gotcha
can
with
do that.
somebody else's, or you could double check your own before you
So
submit it so no one else could play gotcha with you.
exactly. And so like that's so the workflow I'm imagining how I would have used this is I put my work in here and I click the button and I can quickly get a sanity check on like did I make a mistake in putting a cite in there wrong that doesn't show up? Did I cite things for the reasons that I should have cited them for?
Yes.
And so like
And
this
here's
is
one in
all to the
orange
good.
that they cited a cautionary um, case from the same court. So you better be careful here. So let's click this. And so I could click through to the full case here and see like this is a cautionary case. Should I be citing this? And then you could go through and find um in this particular case it declined to follow on one thing but followed on another. So if you're going to be using it, here's the one we were talking about before where
Yeah.
there's two issues. One of them it declined to follow on, one of them it followed on. In
Yeah.
this case, it distinguished. So this case might be a little murky to use. So you just want to make sure that you are using it correctly.
Yeah.
And you see that right in the citationator. And then there's this concept of ambiguous um, citations, and that means sometimes cases appear on like the same page. Let me find a different one down here. Um, they appear on the same page in the reporter, but maybe you could narrow it down a bit.
Mhm.
Like uh this one seems to be pointing to the same one. But in any case, they were, again, just make sure that your citation is right
Yep.
and make
So
sure
if it's
that
mentioned
everything
in
is
one
okay.
paragraph at the top of the page in one way and mentioned as part of a different issue at the bottom of the page, under like what could be semantically a completely different section, but
Mm.
might be citation-wise the same page, this is where we need to disambiguate what each of those references means. I think.
Exactly. Or it could appear on the same page of a reporter as another case, like maybe one ended and
Right.
the next one started. And
Good
it's
point. Yeah,
like,
it could be
are
a
you gonna,
completely different case. I hadn't even
yeah.
thought of that.
So yeah, so that is the last of our tools. And as you can see, it opens up plenty of green field for playing and having fun and researching and doing everything else you might need to do.
Yeah, what fun. So because I'm not practicing law at this point in my life, to me, this is just fun and interesting. And it is related to the legal and the tech work that I do. But in addition to fun, this just looks enormously practical and like like a real utility boost for people that are now, toiling in the fields of the practice of law.
Yeah.
And all the related kind of allied fields. And so just kudos to you. I know it's been a long, um, kind of like effort to get to this point. And I'm just so pleased to see this set of releases and how you're starting to achieve what's always been the potential of this kind of goal that you've been after for so long. And just it's a great moment. And thank you for taking so much of your time today, both
Oh
of
no,
you,
this
to
it,
walk me through this and to do it in the format where we're videoing it so I can share it with my broader community. And I just can't wait to see how everybody starts to use and enjoy the amazing capabilities and resources that you're now making available. So bravo.
thank you. And I think
Thank you.
this summer while people are at the lake swimming, I'm gonna start loading in statutes and regulations so we could do those too.
Yes, yes, those are my favorite. I
Maybe I'll do it in my bathing
have
suit
favorite
at the
children
lake.
in the law,
Yeah.
but
There you go.
it's regs and statutes all the way for me.
Yeah. Yeah.
Good.
Indeed. And thank you, Daz, for your support and friendship.
Yeah, it's really incredibly helpful, and
Yeah.
we appreciate your honesty. Like, there's been things that we've showed you where you're like, "What the freak is this?" So you're not always this exuberant about our.
No, he's a hard grader.
That's
Yeah,
true. Yeah. Well, I like to keep it real, and y'all are great at being able to take feedback, good, bad, or otherwise, and adapt. And it's really, innovation's a game of wise adaptation. And so, just again, kudos on you all for being able to adapt and to evolve, describe, ever closer to realizing the dream that you have. And it's a good dream, and I'm so glad to be able to be part of your journey. So with that, why don't we wrap up now, and I look forward to seeing you all again on Zoom, and then in the fullness of time back in Boston.
nice.
Yay.
Thank you.
Thank you.